Hello students, in this video we are going to start with the new chapter in your civics, and that probably is the last chapter of your civics, and that is chapter 5, the High Court and the Subordinate Court. So we will quickly do this because it is not, as a matter of fact, so difficult to understand this chapter, because it is all the more replica of the previous chapter, just in the lower scale. The meaning is, we have done previous chapter as Supreme Court. All the powers and functions of the Supreme Court are very similar as they are followed in High Court. So in this chapter, as we are doing High Court, we'll be talking about the same powers and functions. So we'll not be doing it much in detail as we have already done it in the previous chapter. And then in the later part of the chapter, that is subordinate courts, there we'll focus on the various courts that we are talking about in the other realm, that is below, under the lower High Court. So here let's quickly begin with the High Court explanation, and we'll try to keep it as short and concise as possible. As per my book, my edition, it is page 210, the High Court and the Subordinate Court. The most important thing about the introduction of the High Court, we see that the Constitution of India provides about for a High Court of each state. For each state, they have to have a particular High Court, and this is given by the Constitution. Parliament, with their own particular decision, can even establish a High Court, for at least a common High Court for two states, or for a state and a union territory. That depends on the size of the area and the population of the area combined together. If it is too low, too less, then two or more states can be included in it, or maybe a state along with the union territory can be added and given one particular High Court. Besides that, there are right now at the moment there are 24 different High Courts, where there are many of them even given a jurisdiction over more than one state. And it is only among the union territories, only Delhi is the union territory which has got a High Court of its own. Besides that, even Goa, Daman and Diu, they are all under the you can say decisions of Judicial Commissioner. Besides that, there are many other union territories, but they are all under the combined High Court jurisdiction, and that means they are sharing their High Court with some or the other state, whichever is nearby state they are related to. So there they are using those particular High Courts. Now next is, when we are talking about High Court, we need to understand the composition of the High Court. As we did in the Supreme Court, there is one Chief Justice and 30 other judges. Over here we can say that each High Court consists of a Chief Justice. Along with that, there are other such judges as the President feel that it is required. Accordingly, they will have that many appointments. It is not a fixed number, because some High Courts will be looking after a huge state, whereas some of them might be looking after a very small state. So we cannot have a set number of that many advocates and judges over there, because that totally depends on the sizes and the areas of the jurisdiction of those particular states. So here we see, besides all the appointment that is decided by the President and the Chief Justice, it is the additional judges. President can also appoint the additional judges for a temporary period of time if he thinks that more work is to be done, and moreover he can also appoint an acting judge. This acting judge is going to work all the things of a particular judge who has been a permanent judge, but due to some reason, maybe illness, maybe some particular reason, he is not able to perform his duties at that particular moment, at that particular brief time period. Till then, an acting judge will perform all its functions, all the functions of the permanent judge in his absence. That is an acting judge who will be accepted or who will be appointed by the President. Next is qualifications of the High Court judge. Obviously, they are very simple. They are supposedly the common things that we have done in the Supreme Court and all the other government authorities. First, he should be a citizen of India. The important thing you have to keep in mind is he should be 62 years of age. Along with that, he has to have a judicial office experience of at least 10 years. That means in some judicial office he should have been working for at least 10 years, or rather he should be an advocate of the High Court at least for 10 years. Next is appointment of the judges. When we are talking appointment of judges, he is appointed by the President, and that is done, not solely the President is making the decision. He has to consult the Chief Justice of the Supreme Court as well as the governor of that particular concerned state, which state is getting that particular appointment or the judge. Next is the president can also have other judges appointed. President can also appoint other judges also, but in doing that particular thing, again, it is not his whole sole decision. It is basically the president has to consult the Chief Justice of India. Remember the names of the posts. Chief Justice of India, then next is governor, and besides governor, that means governor of that related state, and besides that the Chief Justice of the High Court of that particular same state. So both the Chief Justice of Supreme Court also, that is Chief Justice of India, and Chief Justice of that particular state, along with the governor of that state, are going to have a consultation, and then they are going to decide how the other judges to be appointed, and all that decision will be taken in a, like you can say, in a particular core group meeting over there with all of these. So they are the concerned authorities. Next we see, once a person is appointed as the High Court judge, what are the various, you can say, terms and conditions of service that he has to serve, that the way he has to work. It is, first is removal and retirement we see, and the transfer. The High Court judge can enjoy his office, his tenure, till he attains the age of 62. That is, there is no term of 5-year, 10-year or any such thing. It is basically a job where a person is appointed for a fixed age, and that is the age of 62 years. After that, he is supposed to get retirement. He can even work, but there are certain limited conditions, or even there is a condition that he can work, but that is just honorary. He will not be working as for the salary or money, because he would be getting a pension also. So that is why he has certain restrictions after retirement. A judge of High Court can be removed by the president only on the grounds of proved misbehavior, and that again cannot be immediately taken under consideration. It has to go through the entire parliament, and they have to decide with the 2/3 majority. If that happens, then only the movement will proceed, or the movement means the removal of the judge, and this movement is known as impeachment. So we can say the judge has been impeached with the 2/3 majority. Next we see, second is, the president can transfer the judge from one high court to another, but while he does that, he need to keep in mind few things. First of all, orders for transfer can be issued after he has had a consultation with the Chief Justice of India. So with his agreement only, then that particular thing can be proceeded. Chief Justice of India's recommendation that where the person has to be sent and who has to be sent in his place, all that recommendations has to be properly decided and consulted with senior most judges, 4 senior most judges of the Supreme Court. They will decide on that, where this particular judge will be sent and who will be sent in his place. So 2 decisions have to be taken in one particular transfer, because 2 people has to interchange. Besides that, when this interchange is taking place, another thing has to be taken in mind consideration is the Chief Justice views of the High Court, one from which the transfer is being made and the other from where it has to be where he has to be sent, has to be obtained. What are their views in regards to these transfers, the person receiving the judge and the person who's sending his judge to that particular place. And sometimes it is not just mutual that a judge from A point is going to B and B is going to A. It can be the person from A is going to B, and the person from judge from B point is going to the C point, and then from the C point the person might go to some other place or might go to the first place. So there might be many judges interchanging. So that totally depends on where the person is going and where the person is receiving. They need to get a particular view from both the other places. So that is how the thing has to be done when the transfer takes place. And if a particular judge is transferred, in that case he is supposed to get a compensatory allowance for proper reallocation for movement, everything, and that is like a bonus extra on his salary. So that is besides his salary, in addition he will be given a compensatory allowance. Next we talk about, when we are talking about the salary and allowances, it is all the salary and allowances, the monthly, are decided by the parliament. It is not the president who's going to make any changes. And besides that, they get various other facilities, and that is first of all a rent-free accommodation, and along with that other allowances from time to time. And after the retirement, they are even allotted a proper pension, which is a good pension, so that they do not have to work or practice after their retirement. It is just said that they should not be practicing, though they can practice after their retirement in some or the other, that we'll do in the next topic. Here we see the salaries do not change in any particular kind of conditions in the country, that is adverse conditions or emergency or any such thing, because their salaries are charged from the consolidated fund, and that consolidated fund is always kept separate. It is for an unforeseen emergency, but it is enough to give the salaries for the such positions, so they do not change during the emergency conditions also, and during many other crises or things going on in the country, because this is totally separate from the government fund. Next, we see reservation restrictions on the practice. As I was telling you earlier right now, that he cannot work after his retirement because he is given a pension for that reason. But besides that, if a person is really very you can say expertise in his judgment and a very good jurist, then he can be asked to take certain decisions and give a judgment in certain places for the Supreme Court, or otherwise in those high courts where he has not worked. Otherwise, he is not asked to go to any other tribunals and give judgment. So only few high courts where he has not worked, or otherwise in the Supreme Court. So these are the restrictions, and there he will not be given any particular salary. He might be given certain honorarium, but that is not a salary. That is, he cannot charge any fees for that. Next is other conditions. A judge may resign by writing to the president, whatever his condition is, or for whatever reason he is not able to work before the age of his retirement. And the office of a judge can even fall vacant if he is being transferred by the president, or if he is promoted to become the Supreme Court judge or a particular such higher designation. So in that case, his office can fall vacant. Otherwise, the office falls vacant only after the retirement, and that is at the age of 62 years. Now we see the powers and jurisdiction of High Court. So it is just the same when we are talking about powers and jurisdiction. The first power and thing is, in terms of jurisdiction, is the original jurisdiction. Here the case is directly coming to the High Court, and they are, first of all, we cannot say interstate related because they go to the Supreme Court. Here it is in the state itself, different departments having contradictions or having problems against each other, they will come over here. Especially we can say the state revenue and its collection, those particular cases come here. Straight away the cases regarding the wills, divorce, marriage, company law, contempt of court, they all come to the state High Court. They can be taken to the High Court straight away, because they are even talking about the rights also of the people. And besides that, the power to interpret the constitution is also given to High Court to a particular certain limit, and this power is known as the power of judicial review. That means for the state policies, he is going to have the entire constitution interpreted for them, what policy they can make, what they cannot make, what are the changes they are supposed to make in the policies if it is not fit, or whatever the reason might be. So they are also having a particular judicial review power in terms of the state policies. Fourth, we can say along with the Supreme Court, it is the High Court also which can pass the writs, and these writs are always issued in order to see that the people get proper rights, fundamental rights. So restoration of fundamental rights or cases regarding fundamental rights, obviously they can be taken directly to the Supreme Court, but at the same time they can be taken to the High Court as well. Next, we talk about the second category, and that is the appellate jurisdiction. Appellate jurisdiction means the cases which can be taken into the lower courts, and if the person or the people or the parties in dispute are not satisfied, then they can pass on the case from a smaller court to a higher court and take their case to the higher court, and that is the High Court itself. So those cases which come after being heard or decision being given to them in the lower courts, if they come to the High Court, that is obviously known as the cases on appeal or appellate jurisdiction. They can be divided into criminal cases and civil cases, two different categories. In civil cases, which all cases can come over here on appeal, they are in matters concerning land revenue. Second is in cases where injustice has been done. If the party feels that they have been given some injustice by the lower courts, they can take the court to the High Court. Besides that, when it comes to the criminal cases, it is against the judgment of a sessions judge. So if they are not satisfied with the decision given by the sessions judge, against the judgment of the assistant sessions judge, or against the state when the order of acquittal is passed by the sessions judge. And lastly, if a sentence of death must be confirmed by the High Court That means if a lower court says that the crime is heinous or the victim, the guilty should be given a death sentence, then the lower courts will not penalize him with a death penalty. The death penalty will be straight away given to the High Court. And then onwards, from there onwards, if High Court feels it is of national importance, they can take the case to the Supreme Court. Otherwise, it'll stay over there only, and they can even give that particular judgment of whatever the punishment is, whether it should be given a death penalty or not. It will be decided by the High Court. So these are the powers of jurisdiction, powers of the High Court: the original jurisdiction and the appellate jurisdiction. The only difference is regarding the civil and criminal cases. Otherwise, the powers are just the same as it were in the Supreme Court. Next, we talk about functions of the court, High Court. First, obviously, they settle disputes, that is original disputes, original cases heard, and on appeal, which is appellate jurisdiction. Besides giving jurisdiction and judgment to the various such cases in different spheres of the society, different realms of the society, the next important function that they do is enforcement of the fundamental rights, and that is through the passing of the writs, which are issued in order to give proper fundamental rights to the person who is victim to any particular injustice or any particular, you can say, being devoid of the fundamental rights, or their rights are being not given to them. Next is advisory jurisdiction. High Court can advise any government department, that is in the state itself, legislature, or the governor if they seek it. That means if they require any particular judicial consultation or judicial advice, this High Court is there going to be their advisor for that particular thing. Their advice is not binding on the agency. That means it is not that whatever advice they give, the group, the department and the company has to follow it, or the governor has to follow it. They can think about it. If they are not satisfied with that particular advice, they can totally discard it, or otherwise if they are, then obviously they can use it for the policy making or for whatever reason they are seeking the advice. Next is revisory jurisdiction. The revisory jurisdiction means that High Court can call for a record of a case which has been decided by the subordinate court, and while checking it, they can go through the entire case again if they feel that the judgment was not given up to date, up to the mark, or it was not given properly. There were certain things which can be revised and changed, and things can be done better, or the judgment can be different. So in that case, a revisory jurisdiction will be done, and this power is only by the Supreme Court in regards to all the other lower courts. Here we see a revisory jurisdiction is applicable in the following cases. What are the cases where revisory jurisdiction can be done by the High Court? First, injustice or an error of law apparent on the face of the record. On the record, if one can see that there is particular error has been done in terms of giving proper justice. Violation of the principles of natural justice. Proper justice, natural justice is not given. Some particular ill play is seen over there. Arbitrary authority leading to wrong judgments. Some particular authority is playing foul and trying to change the decision or manipulate the decision. If that is proved and can be noticed, then in that case a revisory jurisdiction is done. And flagrant error in procedure. If the procedure is not duly followed, some particular, you can say, misleading things and some particular ways are being used to derive the attention or to take away the attention of the people from the main point or main proof or from the main particular case, then in that case they means they are trying to manipulate the things, or trying to take away the attention of the case. Like in here we can see even the Sushant Singh murder case recently. That is also a particular thing where most of the times we feel that the proofs are being totally taken in order to deviate our that focus from the main point. So that are the things where revisory jurisdiction can be taken, conducted by the High Court. Then comes judicial review. As we know, all the policies made by the government in the state can be revised and reviewed by the High Court, whether proper fundamental rights are followed, whether there is directive principles in a way are followed. Everything is done for the benefit of the people. So all those things are taken into consideration and they can be checked by the High Court. If they feel that certain things are not done properly, in that case they can consider that particular policy null and void also, or they can ask the people to make certain changes in it. Then next is court of record. We know High Court also, along with just like Supreme Court, High Court also records all the cases, and they usually take all these cases further. The judgment is taken as an example for all other such cases in the High Court or in the lower courts to be follow the same procedure, same example in the similar cases. So that is why these records are stored for further references. Then there are various other functions that we are not doing, and you can read that in your book, but that is not so important. So the important powers and functions of the Supreme Court, of the High Court, we have done. Very similar to Supreme Court, just a few things changes, the names and the designations that you have to keep in mind. Next particular topic we will be taking up the subordinate courts, and that we'll do in the next module. And along with the subordinate courts, if we get time, we will try to do the question answers. So not question answers. We will do subordinate courts and then the court of revenue and lok adalats also. So let's do that later onwards. Right now, today, you can just go through these chapters, these particular explanations, and try reading them in your book also, so that you are thorough with the concepts. And for any problems, any queries, you can always let me know. We will try to solve it out together. So with this, we come to the end of the module. I hope you'll understand the things that we've done, and do let me know if there is anything that is confusing you.